Well, that's actually a good thing that that screen froze, because that gives me an opportunity to bring on Gene Rossi, hashtag 4041, the best. Love having him on as a guest. Gene, I got to get to this. What in the Lord's name is going on in that courtroom? The judge has lost complete control. The witness is telling the judge what they're going to testify to. The judge won't let them use certain things because it sounds better not to use them. That's not a legal reference. She's lost complete control, Gene.
I have two comments. One, the inmate should never run the prison, okay? A witness should not be giving direction to a judge. Number two, baseball. She's like an umpire. After the pitch is made, the umpire takes 30 seconds to decide a ball or a strike. You can't be like that.
Okay, Gene, let's try to frame this issue for our audience a little bit. So what's being argued is that the doctor should not be allowed to introduce certain information that it's overly prejudicial. That's what they're saying. And that through the vehicle of this witness, the jury is going to hear this information, and that the prejudicial value is outweighed by its probative effect. That's why you're seeing the judge say, I don't find it's probative. What she's referring to is evidence rule 403 and 404. These two rules are really important in our evidence code. One allows it to go in with a limiting instruction, typically, where they say you can't use that against him to say if he did this on these previous occasions, he must have committed this murder, but you can use it to judge the credibility of the expert's opinion, or under evidence rule 403, you could throw it out if it would be undue confusion, overconsumption of time, or it's not probative. Do I have that about right?
You do, and don't forget the evidence rules. It's the 700 series. What is troubling to the judge, from what I gather in this kerfuffle, is that this expert, who is a piece of work, by the way, he has done a test that has not been subjected to peer analysis or has not been used before, hasn't really passed that Fry test.
Right.
So that's why she cut off 3 of his factors.
And
but I'll tell you this, Bob, if it comes out that he is sort of a psychopath, I mean, that could mean he'll be found guilty. This is very bad evidence for the defendant.
Yeah, the judge is limiting the actual scientific term, not letting him be called a psychopathic person, but that he's got psychopathy traits. Listen, Gene, you mentioned Fry. That is the United States Supreme Court decision that said there has to be a scientific basis with regard to the validity of expert tests, for example, in this particular case. I heard that it was never used for an NGRI, not guilty by reason of insanity, but it has been used in other contexts. But this is why the judge is concerned. The judge is concerned under Fry, under the rules, that if there's a conviction down the road, that they may get thrown out because of the use of this kind of information before the jury, because it's really prejudicial.
Bob, it goes back to that case you talked about many times, and I love hearing it, where the appellate court praised you for not getting greedy. I am very worried if they get a conviction against this guy, just guilty, that it's going to go to the Florida highest court and it's going to be reversed because this expert was allowed to testify.
Excellent practice point, Gene. Yes, sometimes you need to cut and run. You may have enough information in this case already that you don't need to put in suspect testimony, so prosecutors need to watch out, or years later they're going to be retrying a case. Gene, the chatters are going off the hook with regard to these arguments that are going on back and forth. And while the defense lawyers may be rather disrespectful of the judge in my mind, they are making a good record for that appellate issue with regard to this witness. What do you think?
Oh, I give them an A+. And they're fighting, trying to get that record. And I'm telling you, we said it before, if they get a conviction guilty, this could be a reversal. I don't get a good feel about this expert, and my feeling about the judge's ruling is quite shaky.
Now, Gene, we should also point out that I guess you're allowed to do depositions in Florida of witnesses beforehand, which we're not allowed to do in Jersey. I don't think you can do it in New York. What about where you are? Are you allowed to do deps in criminal cases?
Oh, I only did a couple, what do they call it, depositions, to preserve testimony, but you're not allowed, as a matter of right, to do a deposition in a federal case.
Right, so our audience understands, because one of the people in the control room had asked me this, at depositions where you sit with a court reporter outside the presence of the jury, and you get to basically lob any question you want at that witness. And the defense argued here that this witness, this state's witness, that they wanted to redepose him because of a changed opinion. The judge ruled, I'm not going to allow that to happen because the jury is waiting. But what a powerful tool to be able to depose witnesses. I've never, don't have that opportunity because you don't do that in Jersey and New York.
Well, I've talked to people who do state Florida work, and they actually like it, both the prosecutor and the defense, because if you have a weak witness, you're going to know in that deposition if that witness is very shaky.
Okay, welcome back. Well, Gene, we didn't get too far in the testimony. He's given his credentials after hours of argument, and the jury, boy, they can get really frustrated, right, when they're just sitting there. These people don't know one another. The lawyers are making these arguments, and they're coming back now, and they're going through his qualifications because you have to qualify a person to be an expert.
Oh, yeah, these are standard, foundation questions. But I want to talk about the jury for a minute. When they have these breaks, they get obviously annoyed and frustrated because they have their own lives. But my experience is the jurors become very close because then in the jury room, they start talking about their personal lives and the trials and tribulations. And, I had one trial where the jury would meet every year after the verdict as sort of an anniversary.
That's nice. Yeah. So let's go to the foundation questions, though, just so that the listeners understand. An expert is allowed to give their opinion because of their training and specialized knowledge of a particular thing, not just testify about facts. So he's going to be testifying as a forensic psychologist, presumably stating that the Jonchuck was not insane at the time of the incident.
Yeah, what the prosecution is doing is the guy is eccentric, he is unique, he has issues, but he has antisocial behavior problems. He's not psychotic. And that's where the rubber meets the road. If he's just antisocial and strange, he can form premeditation and intent to kill his daughter.
Right, and the judge went through a lot with regard to limiting his testimony and taking out some of that bad guy stuff under evidence rule 404. There you see a picture of him right there with the girl. I mean, it's hard to imagine, right, throwing that little princess over a bridge and killing her. It's just such a tragic thing, and for those cops to see that literally happening, it's hard, but the defense's argument in opening was you're not going to be able to make sense of what he did because he was insane when he did it. I mean, there could be some sizzle to that argument.
Oh, yeah, absolutely. But I hope we get a chance, Bob, to talk about a statement that Judge Hellinger kept out because it's, quote, too prejudicial. And it was hours before the murder or alleged murder. And he said to a paralegal, the defendant did, if I can't have her, Phoebe, then no one will. And a judge kept that out, Bob, because it was too...
I'm going to find out, Gene. I thought the reason the judge is a very powerful piece of evidence for the prosecution. I think extremely probative. I used to say as a prosecutor all the time, Judge, everything I'm doing is prejudicial to the defendant. Every piece of evidence I'm putting in is prejudicial to them. But I thought the judge excluded that, Gene, because of a discovery violation as opposed to a probativeness argument. Let me find that out. We're going to go to
find that out.
Yeah, we'll find that because that's a very, very powerful piece of evidence the prosecution lost in this case. Okay, Dr. Burston, the state's psychologist, is talking about what he was evaluating with respect to Jonchuck to come up with his opinion that he was not legally insane at the time he threw his daughter off that bridge. Gene, very good witness, very good cadence. The prosecutor snuck a sneaky fastball in there, talking about how he also testifies not only for the defense, but for that particular law firm, which I assume is the public defender's office. You could get kind of spanked for doing that in other courts.
Well, you know what? It does show that he's not someone who only testifies for one side. And I don't think it was that bad of a question. It was a curveball with some grease on it, though.
You know, when I was prosecutor, I used to use a psychiatrist all the time to do forensic evaluations, and he started doing them for the defense. Not that I have a problem with that, but he started doing it for the defense in the county that I was in. So I just felt that was very sticky because of that very issue, that he's bolstering the credibility of the witness not based on facts, but based on relationships with other lawyers. I don't know. It gets me a little queasy.
It does. If he just asked, have you testified for the defense attorneys? I think that would have been fine.
Perfectly fine. Gene, to answer your previous question, the statement that you referenced, which is really powerful because to me it would blow away the defense's case that he was not acting purposefully. That is the statement he made to the paralegal that essentially about Phoebe. We found out from our great producers here at the Law and Crime Network, Gene, that was a discovery violation. It had never been turned over to the defense. And when it was proffered by the witness that was going to testify about it, the judge excluded it. That is a major, major fail on behalf of the prosecution because that is a very significant piece of evidence with respect to mental wherewithal. We got to take a break. One thing that the doctor testified to was he snuck in there that he was spending money on drugs. I want to talk to you a little bit about what I was saying off the camera about limiting instructions. And be very careful that you don't just fill this testimony up with bad guy, bad guy, bad guy, bad character evidence. And the judge can give a limiting instruction to the jury to say, you can use this for purposes of testing his credibility as a witness, but you can't use it as bad character evidence. That is, if he did something bad before, he must have done something bad now. What are your thoughts?
Oh, Bob, it's sort of like 404 other crimes evidence. You can't allow it into evidence to show that Gene Rossi's a bad person, but you can use it to show intent, motive, plan, opportunity. Mm-hmm. And the argument would be that him spending money on drugs is not somebody who's a psychopath. It's just he's got antisocial behavior. That's my argument.
Right, but I'm just, to your point, Gene, before we were talking about prosecutors being careful. I don't know why the prosecutor went to sidebar. It'd be interesting to find out because one of the things that I know that I'd be doing if the judge wasn't doing it, as a prosecutor, even though I'm getting the evidence out, I say, Judge, you may want to give that limiting instruction to the jury so that on appeal, the appellate court can look at it and say the judge properly explained to the jury what they can use it for and what they can't use it for.
What you brought up was a great point, Bob, and you know what I'm talking about. If you're before a judge who is not, he's playing single A or double A ball, and you want to play major league ball, you're going to have that sidebar and say, Your Honor, we think we need a limiting instruction to say, you know, I'm letting this in, but only for one particular purpose.
Right, yeah. So you got to protect your record. You got to protect your conviction. Protect at all costs. Because, Gene, I say it a million times, and you've trained so many prosecutors yourself, it's not just getting the ball across that goal line and winning the game. It's making sure that it withstands the review down the road that you played by the rules. And just because you can doesn't necessarily mean that you should. And this is very kind of testimony that the prosecutor can get tripped up on if they're not careful because they're getting a lot of stuff out before this jury that's bad character evidence, which otherwise may be admissible, but it's got to be done the right way.
Right. And I used to love to try cases in front of judges where if I did make a mistake and I didn't catch myself, the judge would catch it. And I used to enjoy that.
Right. Okay, Gene. So, I mean, we may have some video here about his first appearance. If they could cue that up for us, and we take a quick look at that, Gene, and come back, and I want to talk to you about it on the other side.
Okay, thank you. You hear on the word in the first read, you have no bond. Can you hire your own lawyer? Do you have the wherewithal to hire an attorney, sir?
No. I'm sorry.
He's not. Would you like me to hire an attorney to represent you?
No.
Are you sure?
I want to leave it in the hands of God.
Okay. So you want to represent yourself?
I want to leave it in the hands of God.
Pretty sure God's not going to be representing you in this case? You're going to be standing trial. Would you like someone standing next to you as you're standing trial?
Yeah.
An attorney.
That is pure and good, not evil.
I'll do the best I can to give you a pure and good lawyer. If you raise your right hand.
He can't cut Tom.
Can you raise his right hand?
I don't want a court-appointed lawyer. I want to leave it in the hands of God.
Okay, welcome back. Gene, the audio was a little difficult for me to understand what the judge was saying, but you hear him making these references to he's leaving it in the hands of God. The reason why, I don't know if that's going to come out or not come out, but he clearly is answering the questions. It may be bizarre, but that doesn't mean he's insane.
It's funny. I'm starting to feel there's a little con being played here. The initial appearance, folks, for the listeners, it's not when you're asked to plead guilty or not guilty. You're basically told the charges, and do you need an attorney? Can you afford one? And the way he answered those questions by the judge, who asked really good questions, it seemed a little feigned and pretentious when he said, I'm going to leave it in the hands of God. He didn't look as psychopathic as other times. I don't know. I got a bad feeling if I'm the defense attorney.
Gene, I'm looking at our chatters, our great jury, if you will, Smile NE and V. Garrig saying things like, this testimony showing that the defendant's a manipulator, crazy like a fox, playing the system. This drug and drinking use is coming out over and over and over again. He used the daughter's money, Social Security money, I believe it was, to buy drugs. Gene, I don't know how this is all getting out there. This is really some serious 403 considerations here, and I'm surprised the defense isn't jumping up like maniacs over this.
Unless they want it in, and I don't know why they would want it in. But, Bob, I know there's 403 problems, but all this is relevant to show that he was eccentric, he was antisocial, but he did engage in behavior that was not psychopathic. So it is prejudicial. Mm-hmm. I think it passes the 403 test.
I guess what I'm thinking, Gene, I'm not necessarily disagreeing with you, but I guess maybe I'm concerned that there's not more forcefulness by the court with respect to every now and again re-explaining, if it hasn't been explained already, the basis upon which they can use this. This goes to his opinion as to antisocial personality disorder, but it's chock full of evidence that otherwise would never be admitted, but it is relevant, but it needs to be limited by the court in terms of how the jury is allowed to use it, don't you think?
Oh, absolutely, absolutely. It's like, suppose it came out, I'm making this up here, suppose the psychologist said that, the defendant told me that one of his hobbies is to cut the heads off of squirrels. Okay, then you're getting into really weird behavior, and that would be extremely prejudicial.
Right. Wow. Okay. Listen, fascinating case. Compelling, nevertheless. Admissible, not admissible. Obviously, it's getting out before the jury, and our chatters are demonstrating, in my mind, exactly what this jury must be thinking about this defendant through this testimony. Gene, let's jump back a little bit for our audience and talk about that text, or rather that information that was precluded from the jury. The judge excluded it with regard to a paralegal in a custody battle where she was going to testify, I believe, actually called 911 or contacted the law enforcement authorities that he was going to do harm to Phoebe. What a disastrous thing to not produce in discovery and get excluded. It goes right to intent.
I was thinking about this during the break. I can't imagine that the prosecutors did not have a detective interview that paralegal, do a report, and then I'm sure the report was turned over to the defense. If that didn't happen, I'm wondering why they didn't have this in their arsenal of things that they produce for discovery. I'm perplexed.
Yeah, and Gene, a judge is in a tough spot with that because that is really relevant, and to just wholesale, if you will, excluded is really damaging to one of the litigants. Sometimes the court will give an opportunity for the defense to respond to it and allow it to come in late, but you have to also recall here that all of these expert psychologists and psychiatrists were deprived of that very relevant data, which in my mind could completely change the opinion of the experts. That alone.
Well, the prosecution is arguing, we want to know if their experts were aware of that statement, ignored it, and still came to their conclusion that he was insane. And I got to tell you, I think the judge should have allowed them to recall the defense experts in rebuttal to see if they actually knew of that statement.
Yeah, Gene, look, we talk about often, you know, sometimes things get past you. You got cases, 40 bankers' boxes worth of materials. Yeah. This is like so highly relevant. It's sad to see it get excluded because, you know, in the end, a trial should be about an estimation of getting towards the truth. And that was a really it was powerful enough that it actually caused the paralegal, his paralegal, to reach out because of their concern based on that statement. Wow, what a thing to get excluded. Well, we're just not really getting that timing today. That defense lawyer is standing up there right now, thumbing through her papers, making a very forceful argument during the break. You can always go to the Law and Crime website. We always have those clips posted up there, or the YouTube channel on Law and Crime, because this was a really good legal argument for you law aficionados that are out there about one of the more compelling evidence rules of all the evidence rules, and that's 404. Sometimes referred to as prior bad acts, but it's really not. It's other act evidence that's being admitted. Typically, it's excluded unless, as we talked before, it goes to motive, opportunity, intent, plan, absence of mistake, or if it goes to a defense. There's a couple of exceptions to that rule. The question is how much of this is going to be allowed to get out because it's really bloodying up the defendant, as we know from our chatters here. Gene, we were right on the money. She finally got up and made the argument.
You know, I got to tell you, I have a very bad feeling about what's going to happen after the government gets a guilty verdict, if they do. Bad feeling.
Yeah, look, this lawyer is really laying it out, and I was surprised. She was saying that the judge should have given a curative instruction. Curative instruction is different than a limiting instruction. A curative instruction is saying that the evidence shouldn't have come out and you're to disregard it. A limiting instruction is to tell the jury for what purposes they may or may not use the evidence. I was surprised, Gene, as we noted earlier, that the judge was not interceding here because it at least requires, in my mind, without any doubt, a limiting instruction. Let's go back to court.
It was beating up your mother is, in the community's minds, I would suspect, is about the worst thing there is. So,
and
I said, no, it's not coming in.
Okay, and this stands for the proposition, Judge, that they specifically say. In this case, during the trial, the state moved to present evidence of a collateral offense which occurred nearly a month before the present offense. On April 12th, 1986,
Judge, this is asked and answered, nothing new is coming out here.
Could you please swat him to sit down and chastise him for interrupting?
Miss Manuel, sit down.
I was still speaking. He just stood up and started interrupting me.
That's very unprofessional. Please sit down. We're going to break for lunch until 1:15. Thank you.
All right.
Holy cow. She orders the defense lawyer in the middle of an argument to sit down after she was interrupted by the prosecutor, calls her unprofessional. Guys, I asked the producers to please go and get the clip of the defense lawyer making the motion to exclude or mistrial in this case because the prosecution, she alleges, inappropriately got out all this bad act evidence, which our chatters in the very chat room that we're in are talking about, showing him being a manipulator and a liar and a cheat and a fraud. That's kind of exactly what you're not supposed to be using that evidence for. So they queued up the argument. Let's go to it, and I'll be back with Gene Rossi on the other end. Things are getting exciting here at the...
At this time, the defense is moving for mistrial. The last, I'm not certain how many minutes of Dr. Burston's testimony, but specifically regarding uncharged prior bad acts and specific examples of bad character evidence. He indicated that there were 7 to 8 in-school suspensions, that he was suspended for fighting, that he had disruptive behavior in school, that he was let go. There was a specific note regarding a specific instance that he was let go from a previous employer, being Humana, because he didn't show up. He testified that the last year he spent all of his money on drugs. He indicated that he defaulted on loans on the condo, which, well, I guess we're not even getting into the truthfulness of any of this yet, but that he had defaulted on loans. All of these are inadmissible. The state has not provided any line of cases that would suggest that this does come in by filing an insanity defense. I can tell you I have researched on end, and everything I pull up suggests that the exact same rules of evidence still apply in an insanity defense. And so at this point, we've asked for curative instructions on all. We don't think any of it should come in. If it's coming in, we believe that all of those individual things require curative instructions. They all came in. We didn't have any curative instructions. This is a character assassination. We're moving for mistrial.
Wow, compelling motion. Gene, I'm telling you, I'm somewhat sympathetic to this argument, especially when she's bringing out all the things that the expert testified to. She should have made a timely objection at the time it was occurring, in my mind, but nevertheless, about school, about him fighting, about girls and drugs and defaulting on loans, and saying that he puts on a good show and that he's not authentic. Look, V. Garrick said it right here. This lawyer is making a solid record in my mind.
If I ever get indicted for murder, I am hiring her, A+. And I got to tell you, this is why I like to watch trials. I like to be in a trial. I like to watch trials. It got very tense when that prosecutor, Mr. Manuel, stood up. The defense attorney, almost cut his head off.
Well, so you go to that dynamic. Somebody asked me if I've ever seen anything like this in court before. I guess my answer to that, but yeah, I've seen aggressive lawyering and judges that are losing control of a courtroom. But what was happening was she was making a very cogent, articulated argument based on a very sophisticated rule that most lawyers themselves don't know when they try cases. I've utilized it many, many times. No 404 and 403 like the back of my hand. It is like the most important rule in my mind. And with that, the prosecutor stood up and interrupted her. She then said something to the effect like, "Judge, will you please swat him down?" In other words, tell him to sit down. And she, the judge, with that exasperated look on her face, I love her. She's just like full of like, everything's on her face, this judge, tells the defense lawyer to sit down. And she's like, "You're telling me to sit down? He's the one that interrupted me." The judge says, "Sit down." The lawyer concedes and sits down. And then the judge says, "You know what? We're taking a break." Holy cow, Gene.
Get out the popcorn. Salt and butter, man. I'm loving it.
I know, as opposed to that other, like, we can say one thing for this judge. You got to say one thing. She is keeping it entertaining for us fans at the Law and Crime Network, Gene.
Oh, Bob, I would love to go out and have a beer with her and go on the beach. She's a great person.
Yeah. So just a little bit of throwback, Gene, just so our audience understands the interplay of what goes on here. You articulated the prosecution argument before. Under this evidence rule 404, which is a rule of exclusion with limited exceptions, you opine that the prosecutor's argument here is to say it's relevant to the opinion that the expert is giving as vis-a-vis antisocial personality disorder. My argument, on the other hand, was more of the defense argument, not that one is right or wrong, it's a judgment call, is that, yeah, but you can get to a point where you stretch an elastic band so much until it snaps. Right. And not only is he getting out all of these things, he's opining himself about personality characteristics that the defense is arguing are not part of a legitimate scientific testing result or analysis for NGRI. What do you think?
Oh, I think that's a good argument, but the government has to focus on an expert can rely on evidence that is inadmissible. That as long as it's a type of information that expert and others reasonably rely upon. Him talking to the mother is fine. It's just that he brought out a lot of the details that the mother told him.
Well, let's look at it this way, Gene. Let me play devil's advocate here. It is all relevant. That is obviously one of the criteria of admissibility of evidence. But as the judge is referring itself, she is the gatekeeper of the evidence, the judge, and can determine under evidence rule 403 that the prejudicial value is outweighed by the probativeness of the evidence is outweighed by the prejudicial effect. So the judge does have power to limit this kind of testimony. No doubt in my mind about that.
Oh, absolutely. And Bob, as you know, they have very broad discretion to limit evidence. And I got to tell you this, if I'm a judge in a criminal case, I'm going to exercise my discretion in favor of a defendant because you do not want to get reversed on appeal if there's a conviction.
Yeah, and I don't know. I think that this, in my mind, I'm just queasy about it. As a prosecutor, I'm saying this, as a homicide prosecutor, I would not be going in the depth and detail of the character assassination that's occurring here for the very appellate issues that you raised, Gene. They've got enough evidence in this case. Don't get tricky. So, Gene, a pretty dramatic downfall for this president. A high-level positioned person entangled in the snares of the Larry Nassar debacle, horrible crimes committed while he was at that university for those poor kids in the gymnastics team, now sitting as a defendant in a criminal courtroom at a preliminary hearing. What are your thoughts?
Well, you had a misstatement of NASCAR, but this whole situation was like a NASCAR wreck. Here's what I don't believe, Bob. I don't believe this, that Dr. Nassar, who had at least, and I want to say at least 60 victims, probably many more, that none of them came and told people, sports doctors, the administration, that we have a doctor who's a sick person. And I find it hard to believe that the president of that university didn't have knowledge that Dr. Nassar could possibly be a sick person.
Yep, and that's why the prosecution went after these officials, because you may not be committing the acts, but you're providing the environment for which they're allowed to continue. No matter how you look at that, it's disgusting and a gross dereliction of your obligations to those students. All right, Gene, so this is the assistant counsel at Michigan State University, and they're going through the Title IX policies, and she, I guess, is the person that was responsible for investigating claims of sexual harassment. She's in a tough spot.
She is, and she's the one who interviewed Amanda Thomashaw, who was the cheerleader who went to Dr. Nassar, and of course, he didn't treat her as a patient; he treated her as an object. And what troubles me a little bit is that Amanda Thomashaw was interviewed by this attorney, Miss Moore, and then evidently this attorney then briefed her boss, Miss Russell, and I got to tell you, it's hard to believe that the president of the university didn't get an email, a text, a phone call saying there could be something rotten in Denmark.
Yeah, you know, there's a couple of cases that are swirling around the country right now where those very arguments have been made in a number of contexts that the higher-ups did not, in fact, know that the information was actually kept from them. And I think a lot of that has to deal with, I go back to my days as a prosecutor and my two bosses that I had, and they were very different styles. And the one guy people were afraid of, scared, they didn't want to get in trouble, and they kind of, I'd imagine a lot of information got buried from his attention. The second guy wanted hands-on, was very good to us, and we were much more open with information. I mean, it can be that the president is on this ivory tower and just not receiving the data.
You know, Bob, that's the sort of what the Joe Paterno people were arguing, that Joe Paterno was this icon, you know, famous football coach. He didn't know what was going on with Sandusky, and that dog don't hunt. That dog don't hunt.
I mean, it didn't for him, and there were a lot of reasons for that, I think. But I'm just saying that it is certainly something that the prosecution is going to have to bring information about. And from what I understand, there may actually be email information that would suggest the president was aware of this.
And they do. And I think the prosecutor in a statement, either in court or outside, said that there were some items on the agenda, the handwritten notes of President Simon, to strongly suggest that there was a meeting where this issue was discussed. And I think it was in 2014, or it was in early in the stages, way before President Simon's meeting with the police officer in May of 2018.
Gene, real quick, you may know or not know, and it's fine, we can look it up, but is the former President Simon, is she facing jail time for this if convicted?
Yes, she's facing 4 counts of lying to a peace officer. It was a sergeant. 2 are felonies and 2 are misdemeanors. And last I looked, the felony includes jail time.
Interesting.
And a misdemeanor.
Yeah, yep, okay, definitely. All right, Gene Rossi, thank you so much as always. We've got a lot going on here. Okay, Gene Rossi, another sidebar. So, Judge has got a different temperament on the other side of this break. She's basically swatting, for no pun intended, a word used by the defense lawyer earlier about the prosecutor, basically overruling her objections, and the defense lawyer continues to ask for curative instructions. So you notice a different temperament from the judge?
It's a makeup call, and here's why. saw it all the time. She kept out that statement, if I can't have her, nobody will. So took a big bone and a big piece of evidence from the prosecution. And my view is she's making up for that by giving the prosecution a lot of leeway on direct exam of this doctor.
Right, and this doctor seems very credible so far. I mean, he hasn't been cross-examined, and from all accounts, by how this defense lawyer is acting as she discusses things with the court and with co-counsel, or her adversary counsel, that is, I'd expect a pretty intense cross-examination from this lawyer. If she does it.
Yes. This cross-examination better be very effective. If it is not, there's a high risk that there could be a guilty verdict.
Well, that's a good point, Gene. To our people that watch, and we have a lot of law students and lawyers that are budding attorneys and trial lawyers, is to be very careful with your expert witnesses that you're cross-examining. I always like to use that example, Gene. You don't want to get into the cage with the bear, the expert being the bear. It takes a very special kind of cross-examination, much different than when you're just cross-examining fact witnesses.
Yes, and this is a good witness. He doesn't lose his composure. He's a little too professorial sometimes. I didn't really like when he was kind of lecturing the judge. So if I'm doing a cross-examination, I try to get out that side of him where he gets a little bit condescending. And jurors do not like condescending witnesses.
Right. And the types of questions that you would ask on cross, Gene, I tend to, with experts, being very tight, very specific questions, because I don't want them going on and waxing poetic when they know the area generally better than the lawyers do.
Right. But they should not engage in the cross-examination that we saw last week. Remember that, Bob? Where the chatter folks couldn't stand that guy.
Yeah, in terms of the lawyering that's going on, I mean, how you're approaching any witness, a lot of it depends on how that witness is answering your questions, and you got to kind of make sure that you don't turn the jury off. Actually, one of the things that happened in this case earlier today, and so many things happen in Jonchuck, it's kind of hard to keep count of, was that one of the jurors during voir dire indicated that he watched Facebook, and the defense, after the court questioned, the court asked, do anybody want to ask any questions? And the defense attorney, the female that was arguing with the court all morning long, asked him some questions. I thought that could be kind of perilous when you're doing that, because you could really turn a juror off like that.
Oh, I mean, we all have war stories. We had a jury issue once, and the defendant insisted that the court bring out a juror, and the defense attorney was asking questions, is this juror? And I'm firmly convinced it was one of the reasons why I got a guilty verdict, because that same juror became the foreperson of the jury.
Wow, yeah, juror psychology, I think, is really important. They're the ones ultimately making the call, and they're watching everything. And you have to be sensitive as an attorney that they're watching you too, and that you got to be credible, and you've got to be believable, and you got to deliver. So it's very, very important, because the jurors don't like you, they don't like your case. That could be a problem. Let's go back to court. Okay, Gene. So don't do it ad nauseum rule. So this is a hearing again about how much of this bad act evidence is going to be allowed to come out through this expert. Expert witnesses are not supposed to be there for the wholesale introduction of otherwise inadmissible evidence. Well, I'm throwing a lot of legal terms out there today, Gene.
Wow.
Yeah. So, but the judge is allowing it, but not to go on ad nauseum. Please define that for me, Gene. What guidance do you take from that?
Well, ad nauseum to me means I'm about ready to fall asleep if you keep repeating the same arguments, both sides. That's ad nauseum.
Yeah, I think she was kind of maybe indicating, like, not too many, I don't know, some sort of limitation. Because one of the pieces of testimony that's going to come out, I guess, is that this guy, Jonchuck, you got to appreciate his level of dimension. Polished stairs so that his uncles would slip, in fact, did fall down a flight of stairs to show that he has a lack of guilt, remorse, and empathy, which would be the characteristics of antisocial personality disorder. I mean, these are really bloodying this guy up.
Oh, I think this witness, I like him a lot. I'm curious to see how the cross goes, but this is a beautiful rebuttal witness. And I think I know why he's not going to the final issue, Bob, about whether he was insane. I don't think he's properly qualified with his training and experience to go for the kill in sense of saying he was not insane.
You know, we had talked about that when we were off, so our viewers are aware. I'm not sure whether he's going to offer an opinion on that or not. I'm a little confused procedurally about what's going on in that courtroom because a lot of that was occurring outside the presence of the jury, but I guess we will see. All right, Gene, so we got some testimony out. Prosecution's basically getting out everything they want. The judge is being pretty matter-of-fact with these defense objections, overruling them. And our good friend Linda Kenny Bodden was on Twitter saying that she disagrees with me about the defense lawyers. She thinks the defense lawyer is doing a passionate, good job. I agree. The defense lawyer is doing a passionate job and making a great record. Final thoughts, Gene?
I think the defense attorneys are doing great. I really do. And if there's a guilty, there could be a reversal.
Yeah, I think that they're making all the arguments they need to make. They're doing it repeatedly. They're not backing down. And that's just going to look great the more times that they can do that for. If there is a conviction, which in my mind is a likely scenario here, they will definitely have a way to argue on appeal that this information unduly prejudiced the defendant, had little probative effect, and should be reversed. Who knows? We'll see. They can try. It doesn't mean they'll be successful. Gene Rossi, my friend, you are the best.